But anyway, let me kind of give you an idea about this declaratory judgment thing. Now, you can go in for declaratory on anything, because you're going to call the opposition in to rebut it as a defendant. See what I mean? So you're going to sue whoever for declaratory judgment. Now, this particular case right here, we were looking at suing the Department of Treasury, doing business as the IRS. Because what had happened, this guy kind of let things, go along for a long time, and they had liens and levies against him. This is going to be, we titled it Petition for Declaratory Judgment. Now, you understand in the admiralty law, there's only two things you can do. You can petition or you can give notice. Well, there may be another thing too, but for the most part, when we're doing any kind of thing in the admiralty court, we're either petitioning the court to do something, or we're giving them notice that a certain thing exists. So this particular thing here is going to be a petition for declaratory judgment in the record. And it went into the United States District Court somewhere in Florida. Let's say John Smith plaintiff versus, in this case, we styled it Department of the Treasury. It could be the IRS itself. You might want to just do the IRS if that's what you're working on. But it was John Smith plaintiff versus Department of the Treasury, doing business as the IRS, for-profit General Delaware Corporation, the corporation date 7/12/33, file number 0325720, also known as trust number 62 in Puerto Rico. Anyway, that's going to be the defendant. And somebody put down here too, you might always remember to do, is put down file on demand. Now, sometimes you go into court and they, we don't want to file that. Look here, file on demand. You got some reason you ain't going to do that? Okay, give me your bond. But anyways, if you put file on demand down there, it'll get a little bit more juice for you going. Yeah, I put it in bold letters. Bold letters, File on demand or else. I'm going to stand here and hold my breath until I turn purple. All right, so it goes something like this. John Smith, a real party in interest, petition, regardless if deemed inartfully pled. I think y'all heard that language, haven't you? Haynes v. Kerner. They can't throw your pleadings out just because you're not an attorney. Y'all understand that? I'll read it to you. John Smith's petition, regardless if deemed inartfully pled, must be held to a less stringent standard than formal pleadings drafted by bar-admitted attorneys, and can only be dismissed for failure to state a claim if it appears beyond a doubt that John Smith can prove no set of facts in support of his claim which would entitle him to relief. Then it cites all the court cases, blah, 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 blah. And so then we say, John Smith's factual allegations in the text must be accepted as true, along with any reasonable inferences that may be drawn therefrom. John Smith's petition must not be read too narrowly, but must instead be read liberally so that any inferences may be drawn therefrom. Now, that's kind of a catch-all, and so we like to put it right there on the very first thing we do on the page. So now we're going to establish jurisdiction. So under the title of jurisdiction, declaratory judgments are provided for by both federal and state law. In this instance here, we quoted 28 U.S.C. and whatever reason we use California Code Civil Procedure. Whatever state you're in, just go find the equivalent if you think you need to. And then we see also see the Uniform Declaratory Judgment Act. Declaratory judgments permit parties to a controversy to determine rights, duties, obligations, or status. The operation of the Declaratory Judgment Act is procedural only. Relief under the Acts is available only if the requisites of jurisdiction, in the sense of a federal right or diversity, provide foundation for resort to the federal courts. And so how would you establish diversity? Well, this is the heading right here. Okay, there's only two ways you can go into federal court instead of going into state court. And one of them would be because the parties are diverse from each other. They can live in separate states. They can have one party that's a fiction and the other party a real entity. There could be any manner that would cause diversity. And the other way you can get into federal court is if there's a federal question. And our favorite federal question, of course, is due process. But anyway, you have to fall into certain categories before you can go in the United States District Court. But you do the same thing in state court. But we just wanted to do it in the federal in this case because we were dealing with an IRS issue. See, the Declaratory Judgment Act allowing relief to be given by way of recognizing the plaintiff's right, even though no immediate enforcement of it was asked. In other words, you can simply get the thing on a record for now to all eternity. You don't have to have something going on that you need this for. You can do it right now. That's why I'm saying you can use this as a preemption. Whatever that means. You can preempt any kind of thing by simply getting it on the record now. You don't have to wait until somebody banging on your door with a arrest warrant or something like that. Get it done now. See? And you can do it by declaratory judgment. Let's see. The requirements of jurisdiction, the limited subject matters which alone Congress has authorized were not impeded. Anyway, it tells you all the qualifications there for getting into the United States District Court with the declaratory. Case for controversy. The United States Constitution, Article 3, Section 2, limits the exercise of the judicial power to cases and controversies. The Declaratory Judgment Act, in its limitations to cases of actual controversy, refers to the constitutional provision and is operative only in respect to controversies in which are such in the constitutional sense. A justiciable controversy is thus distinguished from a difference or dispute of a hypothetical or abstract character from one that is academic or moot. The controversy must be definite and concrete, touching the legal relations of parties having adverse legal interest. It must be a real and substantial controversy, admitting of specific relief through a decree of a conclusive character is distinguished from an opinion advising what law would be upon a hypothetical state of events. Well, that's a bunch of all lawyer talk. You can read all that. We put it in there just because it looked good. Standards of review. That's all I'm saying. You're setting it up. You're setting up the jurisdiction, and these are the things that have happened historically in the court cases in regards to declaratory judgment. So we're just setting it up there so that, see, here's the thing. Anytime you go into court, you should leave no stone unturned. You're telling them what it is you want, and you're telling them why it is that they need to give you what it is you want. So you got to set it up. That's all I'm saying. So this here has to do with the law and all that kind of stuff in regards to declaratory judgment. Then it's got another section here on standards of review, and you can read all this at your leisure when you get this. And so we go all through all that. And then we go into a affidavit pleading. Now, let me explain to you, in a federal court, you don't have to do affidavits. In the federal court, everybody presumed to be telling the truth. So you can't lie in Fed. And so it's not necessary to do an affidavit in a federal pleading, but we do it anyway because it's just good sense to do it. And so, I, man, appearing in John Smith, do state that I'm over the age of 21 years, competent with first-hand knowledge, and that. Okay, now we go into jurisdiction and venue. The affiant has been doing business as John Smith within the jurisdiction and venue of this court. The IRS or whoever diverse from John Smith. Now, in this case, we're using John Smith in upper and lower case. See? The first line was an all-cap name, which is affiant has been doing business as John Smith, the vessel. Then the next line down, we're going into John Smith, upper and lower case, to demonstrate the diversity. Because one of them exists in one world, and the other one exists in another. So it is diverse. It is truly diverse. So the IRS diverse from John Smith and foreign to the U.S. vessel, John Smith, also does business within the jurisdiction and venue of this court. See, the court can't have jurisdiction over somebody that's out here in Timbuktu. They got to be within their area. Jurisdiction is granted. See, I'm granting jurisdiction. Now, look here.